My name is Carmel, and I was 32 when I faced my ex-boss Marcus Wilson in court that day. His smug face beamed with confidence as he testified. "Your non-compete will muzzle you for a year," he announced, staring me down. I stayed silent, watching the judge flip through my lawyer Grace's brief. The judge cited statute section 48.112 and smiled at their attorney. The lawyer's face froze. He frantically scribbled on his notepad and shoved it in front of Marcus. On it were just two circled words: settle, now. Let me know in the comments where you're watching from and if you've ever dealt with unfair workplace contracts. Hit like and subscribe if you want more stories about standing up to workplace injustice, and let's dive into how I discovered the forgotten law that changed everything. Before the courtroom drama, my career in software development had been steadily climbing. After 7 years in the industry, I had built a solid reputation for creating innovative user interface solutions. My previous employer, a mid-sized tech company, had given me valuable experience but limited opportunities for growth. So, when I received an email from a recruiter about a position at Nexus Technologies, a promising startup with significant venture capital funding, I was immediately intrigued. The company website showcased a sleek, modern office with happy employees collaborating in bright spaces. Their mission statement promised to revolutionize customer relationship management through cutting-edge AI integration. The salary offer was 40% higher than my current position, with stock options that could potentially be worth millions if the company succeeded as projected. My first impression of Nexus Technologies was everything I had hoped for. The office matched the website images perfectly, with glass walls, ergonomic furniture, and a fully stocked kitchen. Free lunches were provided daily, and there was even a relaxation room with massage chairs. During my office tour, people seemed genuinely happy, greeting each other warmly and working together in collaborative spaces. Marcus Wilson, the chief executive officer, personally welcomed me on my first day. Tall, with piercing blue eyes and a charismatic smile, he made a point of showcasing my hire to the entire company during the weekly all-hands meeting. "Carmel represents the caliber of talent we need to take Nexus to the next level," he announced. "Her expertise in UX design and AI integration will revolutionize our product." I was assigned to lead the user experience redesign for their flagship product, a customer management system used by hundreds of companies. The team I worked with included 5 talented designers and developers who seemed eager to collaborate with me. We had daily stand-up meetings where everyone shared their progress and challenges, creating a supportive environment where ideas flowed freely. Stephanie Lewis, the lead developer, quickly became both a colleague and friend. She had been with Nexus since its founding 3 years prior and provided invaluable insights into the company culture and history. "Marcus has built something special here," she told me during our lunch breaks. "He can be demanding, but he rewards results like no other CEO I've worked with." Alan Parker, our data scientist, was equally welcoming. His brilliant analytical mind complemented my creative approach, and together, we developed several innovative features that seamlessly integrated AI with user-friendly interfaces. Our collaboration resulted in a predictive customer behavior system that could anticipate needs before they were explicitly expressed by users. Within 3 months, our team delivered the redesigned platform, and the response from clients was overwhelmingly positive. Customer satisfaction ratings increased by 38%, and several industry blogs wrote about our innovative approach. Marcus personally congratulated me during the company celebration, placing his hand on my shoulder and announcing to everyone that I was the future of Nexus. The first 6 months at Nexus Technologies felt like a dream come true. I received a performance-based bonus after the successful launch, and Marcus hinted at a potential promotion to Vice President of Product within the year. My stock options were vesting according to schedule, and market analysts were predicting that Nexus would be a prime acquisition target for larger tech firms. There were small signs I should have paid more attention to. The way Marcus occasionally took credit for team ideas during investor meetings, how former employees' names were never mentioned after they left, the unusual number of non-disclosure agreements we were asked to sign. But I was riding high on success, and optimism convinced I had finally found my professional home. One evening, as I was working late, Marcus stopped by my desk. "You know, Carmel," he said casually, "I see a lot of myself in you. Ambitious, creative-driven." He paused, his expression shifting subtly. "Just remember that at Nexus we succeed as a team. Individual recognition can sometimes disrupt our carefully built culture. I nodded, not fully understanding the warning beneath his words. It would be months before I realized that conversation marked the beginning of the end of my dream job. The atmosphere at Nexus Technologies began to shift about 6 months after I joined. Our redesigned platform had gained significant attention in the industry, and I was becoming recognized as an innovative voice in user experience design. Several technology publications had featured our work, and my name appeared prominently in these articles as the lead designer behind the breakthrough interface. An email arrived in my inbox that would unknowingly trigger the beginning of my problems with Marcus. The organizers of Tech Forward, one of the most prestigious technology conferences in the country, invited me to be a keynote speaker about the AI integration techniques I had developed at Nexus. This was a career-defining opportunity that could establish me as a thought leader in the field. Excited about the recognition, I immediately scheduled a meeting with Marcus to share the news and get company approval. I expected him to be thrilled about the positive publicity for Nexus. Instead, his reaction was unexpectedly cold. "Interesting," he said, leaning back in his chair after reading the invitation. "But I think we should send Bradley from marketing instead. He has more experience with public speaking, and this is really a company achievement rather than an individual one." "But they specifically requested me," I explained. "They want to hear about the technical innovations we implemented." Marcus's expression hardened slightly. "Carmel, you developed those innovations while working for Nexus, using Nexus resources. The intellectual property belongs to the company, not to you personally." I left his office confused and disappointed, but decided to advocate for myself. I drafted a careful email outlining how my presentation would benefit the company and increase our industry standing. 3 days later, Marcus reluctantly approved my appearance, but with strict conditions. All slides needed his personal approval, and I was forbidden from discussing certain technical details he deemed proprietary. The conference was a success despite these limitations. My presentation received a standing ovation, and afterwards several industry leaders approached me with questions and congratulations. A prominent technology magazine requested an interview about my career path and design philosophy. When I returned to the office, the atmosphere had noticeably changed. Marcus was unusually distant, and I noticed he had scheduled several meetings without including me, despite my role as project lead. During our weekly team meeting, he announced a reorganization that effectively reduced my responsibilities while expanding those of colleagues who posed less threat to his spotlight. A week later, I was called to a meeting with Marcus and Patricia from the legal department. They placed a document before me regarding the patent applications for the innovations our team had developed. "We need you to sign this," Marcus said. "It removes your name from the patent application and assigns full credit to Nexus Technologies as a corporate entity." "But I was the primary inventor," I protested. "Standard practice in the industry is to list the actual inventors while the company retains ownership rights." "That's not how we do things at Nexus," Patricia stated firmly. "Your employment agreement gives us complete discretion over intellectual property matters." I requested time to review the document with my personal attorney, which visibly annoyed Marcus. "This isn't negotiable, Carmel. It's a condition of your continued employment." The next day, I noticed several colleagues avoiding eye contact with me in the hallways. My friend Stephanie pulled me into an empty conference room, looking around nervously before speaking. "Be careful, Carmel," she whispered. "Marcus doesn't like when employees gain too much individual recognition. Last year, David from engineering got a lot of industry attention for his work, and within 2 months he was gone." "Gone? What happened?" I asked. "Marcus made his life miserable until he quit. Then he enforced a brutal non-compete agreement that prevented David from working anywhere in the industry for a year. Marcus has everyone sign these restrictive contracts, and he's ruthless about enforcing them if you leave on bad terms." I pulled out my employment agreement that evening and carefully read through it. The non-compete clause was indeed draconian, preventing employment with any company that could be considered a competitor for 12 months after leaving Nexus. Given the broad nature of our business, this effectively meant I couldn't work anywhere in my field. Over the next few weeks, I began noticing other troubling signs. My company email was being monitored, with Marcus frequently referencing messages I had sent to colleagues. My access to certain code repositories was revoked without explanation. Team members were reassigned away from my projects, and I was excluded from strategic planning meetings. During lunch one day, Alan quietly informed me that he had been questioned by Marcus about my work habits and contributions. He wanted me to confirm that your innovations were actually building on existing company technology rather than original concepts, Alan said. I told him the truth that your designs were groundbreaking and original, but I don't think that's what he wanted to hear. I began documenting everything carefully, dates, times, emails, and conversations. Something told me I might need this record in the future. I also started researching employee rights and the enforceability of non-compete agreements in our state. What I discovered gave me a small glimmer of hope. These agreements were not always as ironclad as employers wanted employees to believe. As my star rose in the industry while Marcus's grip on my career tightened, I realized I was facing a crucial decision point. Should I keep my head down and surrender to his demands, or should I fight for recognition of my work and contributions? The path forward was unclear, but one thing was certain: my dream job had revealed its nightmarish underbelly. The tension between Marcus and me reached a breaking point 3 weeks after the Tech Forward conference. I received an email from the organizers of DevCon, another prestigious industry event, inviting me to present our latest innovations. Before I could even respond or discuss it with Marcus, I received a company-wide memo announcing that Bradley from marketing would be representing Nexus at all upcoming conferences, including DevCon. When I requested a meeting with Marcus to discuss this decision, his assistant informed me he was unavailable indefinitely for one-on-one meetings with me. Instead, I was directed to communicate through my new team supervisor, a position created seemingly overnight and filled by Richard Marcus's longtime friend with minimal technical knowledge. The final straw came when I discovered Marcus had submitted a patent application for an enhanced version of my user interface design, listing himself as the sole inventor. I only learned about this because a colleague in the legal department, sympathetic to my situation, quietly slipped a copy of the application onto my desk with a yellow sticky note that read, "You should see this." The patent application contained detailed descriptions of my work, including specific elements I had documented in my personal development journal. There was no doubt Marcus had somehow accessed my private notes and was now claiming my innovations as his own. That evening I confronted Marcus as he was leaving the office. I saw the patent application, I said, struggling to keep my voice steady. "That's my work you're claiming credit for." His expression shifted from surprise to cold calculation. "Your work, everything you create at Nexus, belongs to the company, and as CEO I represent the company. Besides, I provided the vision and direction that made your minor contributions possible." Minor contributions. The entire adaptive interface system was my creation from concept to implementation. Marcus stepped closer, lowering his voice. "Be very careful, Carmel. Your employment agreement includes robust, non-disparagement clauses. If you continue making these accusations, there will be consequences." The next morning, my security badge wouldn't open the door to the development lab. Richard informed me that my access had been adjusted to reflect current project needs. I was reassigned to what was essentially a maintenance role, updating documentation for older product versions, a task typically given to interns or junior developers. My isolation became complete when team chat groups were reorganized, excluding me from critical conversations. Meetings were rescheduled without notice during my lunch break or after hours, and then I was reprimanded for missing them. My performance review, previously stellar, suddenly contained criticisms about my difficulty collaborating and resistance to company direction. Alan tried to advocate for me during a product development meeting, questioning why my innovative approach had been abandoned in favor of a more conventional design. The next day he was gone. An impersonal email announced he had decided to pursue other opportunities, but Stephanie later confirmed he had been fired for not being a team player. They had security escort him out, she whispered, during a hurried conversation in the parking garage. They made him sign additional documents before returning his personal belongings. Marcus told the team afterward that questioning leadership decisions would not be tolerated. Fearing electronic surveillance, I began keeping a detailed journal at home, documenting every incident, every email, every conversation that demonstrated the systematic campaign against me. I used my personal phone to photograph key documents and evidence of my original work, being careful to avoid any proprietary code or trade secrets that would violate my confidentiality agreement. The stress began taking a severe toll on my health and well-being. I developed insomnia, often lying awake, replaying confrontations or anticipating new attacks. My appetite diminished, and I lost 15 pounds in just over a month. Friends outside work commented on my withdrawn demeanor and constant anxiety. My sister Jessica became concerned enough to insist I speak with someone about my legal options. This isn't just unfair, Carmel. It's potentially illegal. You need to know where you stand. Following her advice, I scheduled a consultation with Grace Thompson, an attorney specializing in employment law. I brought copies of my employment agreement, the patent applications, and my journal documenting the pattern of behavior since the conference. Grace listened intently, occasionally taking notes or asking clarifying questions. When I finished explaining my situation, she looked up with a determined expression. "What Marcus is doing constitutes a textbook case of workplace retaliation," she said. "The fact that it escalated after you gained industry recognition suggests he's trying to prevent you from building a personal brand that might diminish his control over you and the intellectual property you create." "But what about the non-compete agreement?" I asked. "If I leave, he can prevent me from working anywhere else." "Non-compete agreements are complicated," Grace explained. "Their enforceability varies significantly by state and circumstance. Many companies use them as scare tactics, knowing that most employees can't afford the legal battle to challenge them. So I'm trapped." "Not necessarily. We need to gather more evidence and develop a strategy. In the meantime, continue documenting everything and be extremely careful about what you sign or agree to. If Marcus is isolating you and diminishing your role, he may be building a case for termination or trying to force you to quit." As I left Grace's office, I felt a mix of fear and determination. The path ahead would be difficult, but for the first time in months, I had an ally who understood what I was facing. Little did I know that Marcus was about to escalate our conflict beyond anything I had anticipated, forcing me into a decision that would change the course of my career and life. After 3 more weeks of increasing hostility at Nexus, I reached my breaking point. Marcus had scheduled a company-wide presentation where he unveiled his new interface design identical to the one I had been developing in private based on user feedback. He made no mention of my contributions, instead praising Bradley and Richard for their innovative thinking. That afternoon, I received an email from Human Resources requesting my presence for a performance improvement discussion. The attached document outlined numerous fabricated deficiencies in my work, including unwillingness to collaborate and taking credit for team efforts. It was clear this would be the first step in building a case for my termination. After a sleepless night weighing my options, I drafted my resignation letter. Grace had advised me to keep it brief and professional, avoiding any accusations or negative statements that could later be used against me. I simply stated that I was resigning effective 2 weeks from the date of the letter, and that I would assist with transitioning my responsibilities. Marcus's reaction to my resignation was not what I expected. Rather than showing relief that I was leaving voluntarily, he seemed angered, as if I had somehow deprived him of the satisfaction of firing me. He immediately called me into his office, where Patricia from legal was already waiting with a folder of documents. "Before you leave, there are some matters we need to address," Marcus said coldly. "Patricia has prepared the necessary paperwork." Patricia slid several documents across the table. "This is a reminder of your ongoing confidentiality obligations and an enhanced non-compete agreement that extends your restrictions to 18 months rather than 12. "Enhanced non-compete. Why would I sign that when I'm already leaving?" I asked. "It's a condition of receiving your final paycheck and having your departure classified as a resignation rather than a termination for cause," Marcus replied. "We already have sufficient documentation to justify termination, which would make you ineligible for unemployment benefits and would require disclosure to future employers who check your references." The threat was clear. Sign or face financial hardship and a damaged reputation. With mounting bills and dwindling savings, I reluctantly signed the papers, planning to have Grace review them afterward. My final 2 weeks at Nexus were excruciating. I was required to train Richard on my projects, watching as he took credit for my documentation and ideas in real time. My access to systems was gradually revoked, and team members were discouraged from communicating with me. On my last day, there was no customary goodbye lunch or card. Instead, a security guard stood by as I packed my personal belongings, then escorted me directly to the exit. The reality of my situation hit hard when I began applying for new positions. Despite my qualifications and previous success, interviews suddenly became scarce. When I did secure interviews, they often ended abruptly when the topic of Nexus came up. One hiring manager, with whom I had built a good rapport, took me aside after our conversation. Look, I'm not supposed to tell you this, he said quietly. But Marcus Wilson has been reaching out to companies in the industry. He's suggesting that you stole intellectual property and were fired for ethical violations. Most HR departments won't risk the potential liability. My financial situation deteriorated rapidly. With no income and a mortgage payment due, I was forced to dip into my retirement savings, incurring substantial penalties. I cut expenses, drastically canceled vacations, and even considered selling my car. The stress manifested physically, with frequent headaches, stomach problems, and panic attacks that sometimes left me gasping for breath. 3 months after leaving Nexus, I received an unexpected call from Stephanie. She suggested meeting at a coffee shop across town, far from the Nexus office. When I arrived, she was seated in a corner booth, nervously scanning the entrance each time the door opened. "I had to talk to you," she said, her voice barely above a whisper. "Things have gotten worse since you left. Marcus has become increasingly paranoid and controlling." She slid a USB drive across the table. This contains emails and documents showing how Marcus has been systematically appropriating employees' work and forcing them out if they object. He did the same thing to David, Sarah, and now Alan. There's also evidence that he's been actively sabotaging your job prospects. "Why are you risking your job to help me?" I asked. "Because he's destroying people's lives and careers," she replied. "And because I'm next on his list. He's already started reassigning my projects to Richard." I immediately shared the new evidence with Grace, who spent several days reviewing the materials and researching precedents. But before we could formulate a plan, a certified letter arrived at my apartment. Nexus Technologies was suing me for alleged violations of my non-compete agreement. According to the lawsuit, I had attempted to secure employment with direct competitors and had engaged in discussions about Nexus proprietary technology during interviews. They were seeking an injunction to prevent me from working in the industry for the full 18-month period, plus damages for alleged harm to their business. The lawsuit was a devastating blow. Even if I eventually won, the legal fees would bankrupt me long before we reached a resolution. Marcus was counting on my inability to sustain a lengthy legal battle. As I sat in my apartment that night, surrounded by unpaid bills and lawsuit documents, I felt utterly defeated. But then I remembered Stephanie's courage in bringing me the evidence and Alan's willingness to stand up for what was right despite the consequences. I thought about all the other employees whose innovations had been stolen and careers derailed by Marcus's predatory practices. If I gave up now, the pattern would simply continue with the next talented developer who threatened his ego. With renewed determination, I called Grace. "I want to fight this," I said. "Not just for myself, but for everyone else he's done this to, or will do it to in the future. There has to be a way to stop him." Little did I know that the key to defeating Marcus was buried in obscure legal precedent, waiting to be discovered by someone desperate enough to search for it. The day after receiving the lawsuit, I met with Grace at her office to discuss our options. The conference room table was covered with legal textbooks, printouts of case law, and copies of my employment documents. Grace's expression was serious, but not defeated. "Carmel, I want to be completely honest with you," she began. "Fighting this lawsuit will be expensive and time-consuming. Marcus has Nexus's considerable resources behind him, and they're counting on you running out of money or will before the case concludes." "So what can we do?" I asked, trying to keep the desperation from my voice. "I believe our best approach is to thoroughly research the specific employment and non-compete laws in our state. Non-compete agreements exist in a complex legal landscape, and their enforceability often hinges on very specific details. If we can find precedent that invalidates or limits the scope of your agreement, we might be able to turn this around." Grace suggested I assist with the research to save on legal costs. 2 sets of eyes are better than one, especially since you understand the technical aspects of your work that I might miss. That evening began what would become my new routine. After spending days applying for jobs in adjacent industries not covered by the non-compete, I devoted my nights to legal research. My dining table disappeared under stacks of printed cases, highlighted statutes, and notebooks filled with potential arguments. I started by researching the basic requirements for enforceable non-compete agreements in our state. They needed to protect legitimate business interests, be reasonable in time and geographic scope, and not impose undue hardship on the employee. Many cases hinged on the definition of reasonable and undue hardship. 1 week into our research, I discovered a case from 10 years prior, involving a software engineer who had successfully challenged a non-compete agreement because it effectively prevented him from using skills he had possessed before joining the company. The judge in that case had cited a little-known statute section, 48.112, that limited non-compete enforcement when it unreasonably restricts an employee's ability to practice their established profession. Excited by this finding, I dug deeper searching for other cases that referenced this statute. Most legal databases showed minimal results, suggesting it was rarely invoked. But in a dusty corner of the county law library, I found physical records of cases too old to be fully digitized. There, in a case from 15 years prior, was a potential goldmine. The case involved a company called TechVantage that had sued a former employee for violating a non-compete agreement nearly identical to mine. The judge had ruled that under statute section 48.112, non-compete agreements could not be enforced when 1. The skills being restricted were possessed by the employee prior to employment. 2. The agreement was used primarily as a retention tool rather than to protect legitimate trade secrets. 3. The employer had engaged in documented patterns of suppressing employee advancement. I photographed every page of the ruling and rushed home to study it more carefully. The parallels to my situation were striking. Like me, the TechVantage employee had been hired for existing skills, had contributed innovations that the company claimed ownership of, and had faced systematic efforts to prevent career advancement when they gained industry recognition. At our next meeting, I presented my findings to Grace, who studied the cases with growing excitement. "This is potentially game-changing, Carmel," she said. "Statute section 48.112 has been largely forgotten because newer laws have received more attention, but it was never repealed. And the TechVantage case established a precedent that could directly apply to your situation." "So we can use this to fight the non-compete enforcement?" I asked. "Potentially even better," Grace replied. "If we can prove Marcus used the non-compete as a tool of control and retaliation, rather than to protect legitimate business interests, we might be able to counter-sue for interference with your career prospects. The statute specifically mentions relief for employees subject to bad faith restrictions on professional practice." With this new direction, we expanded our evidence-gathering efforts. I reached out to former Nexus employees who had experienced similar treatment. Most were initially reluctant to get involved, fearing retaliation, but Alan agreed to provide a sworn statement about his termination after supporting me. More surprisingly, David, who had left Nexus the previous year, contacted me after hearing about my case through mutual connections. "Marcus did the same thing to me," he explained. "He took credit for my algorithm, then forced me out when I objected. I couldn't work in the field for a year, and it nearly destroyed my career." Grace helped us document these testimonies in legally admissible formats. Meanwhile, I organized the evidence from Stephanie's USB drive, creating a timeline that demonstrated the systematic nature of Marcus's behavior. The emails were particularly damning, showing explicit discussions about using non-compete agreements to keep talent in check and prevent individual employees from outshining the company brand. As our counter-strategy took shape, Nexus's lawyers increased the pressure filing motions to expedite the case and demanding extensive discovery of my personal communications and job search activities. They even subpoenaed my sister Jessica, claiming she might have knowledge of me sharing proprietary information. "They're trying to intimidate you and drain your resources," Grace explained. "But they don't know what we've found. In legal battles, surprise can be a powerful advantage." 3 weeks before our scheduled court date, Grace filed our response to the lawsuit, including a counterclaim based on statute section 48.112. The filing was deliberately vague about our specific evidence and legal theory, providing only the minimum required disclosure. As expected, Nexus's legal team immediately filed for a summary judgment, arguing that our counterclaim had no legal basis. The judge denied their motion and set a hearing date, ordering both parties to prepare full arguments on the applicability of statute section 48.112 to non-compete enforcement. The night before the hearing, I barely slept. Despite our preparation and the strength of our case, I knew Marcus had more resources and influence. He had already demonstrated his willingness to destroy careers to maintain control. As I finally drifted off in the early morning hours, I wondered if I was making a terrible mistake by challenging someone so powerful and vindictive. But then I dreamed of standing in front of a classroom of young software developers, warning them about predatory employment practices and teaching them how to protect themselves. In the dream, Stephanie, Alan, and David stood beside me, free from Marcus's control and helping others avoid the same fate. I woke with a sense of purpose that outweighed my fear. Whatever happened in court, I was fighting not just for myself, but for everyone who had been or would be victimized by employers who weaponized non-compete agreements to steal credit and control talented employees. Win or lose, bringing this issue to light was worth the risk. The county courthouse was an imposing structure of granite and marble, its high ceilings and formal atmosphere, designed to inspire both respect and intimidation. As Grace and I walked up the broad steps, I noticed a black luxury SUV pull up to the curb. Marcus emerged, flanked by 3 attorneys in expensive suits, each carrying leather briefcases that probably cost more than my monthly rent. "Remember," Grace whispered, "they're counting on intimidating you with their resources. Stay calm and focused on our strategy." Courtroom 305 was already buzzing with activity when we entered. To my surprise, several former Nexus employees were seated in the gallery, including Alan and David. Stephanie wasn't among them, but she had texted me earlier wishing me luck and explaining she couldn't risk being seen supporting me while still employed at Nexus. Marcus and his legal team occupied the plaintiff's table, spreading out multiple binders and laptops in a display of overwhelming preparation. I recognized Patricia from Nexus Legal Department, along with what appeared to be 2 senior partners from Preston and Walsh, one of the most prestigious law firms in the city. Our table, by contrast, held only Grace's modest briefcase and my single notebook. The disparity in resources couldn't have been more obvious, but Grace seemed unfazed, calmly arranging our limited materials with precise movements. "All rise for the Honorable Judge Eleanor Montgomery," the bailiff announced, and everyone stood as a distinguished woman in her 60s entered and took her place at the bench. After the initial formalities, Marcus's lead attorney, Jonathan Preston, presented their case first. He painted me as an ungrateful employee who had benefited from Nexus's mentorship and resources, only to attempt to steal proprietary technology and client relationships. "Your Honor, Miss Walsh signed a clear and unambiguous non-compete agreement, then deliberately attempted to circumvent it by approaching direct competitors," Preston argued. "The agreement she signed is standard in our industry and exists solely to protect Nexus's legitimate business interests and intellectual property." Marcus took the stand next, projecting an image of the reasonable betrayed employer. He described how he had personally mentored me and provided extraordinary opportunities for my professional growth. "Your non-compete will muzzle you for a year," he testified, looking directly at me with a slight smirk. "That's the consequence of trying to take our proprietary methods to our competitors." I maintained a neutral expression, remembering Grace's advice not to show emotion or reaction to their testimony. Inside, though, I was seething at the blatant misrepresentation of our working relationship and my contributions to Nexus. When it was our turn, Grace approached the podium with calm confidence. "Your Honor, this case is not about enforcing a legitimate non-compete agreement. It's about Mr. Wilson using such agreements as weapons to suppress employee advancement and claim credit for innovations he did not create." She methodically presented evidence of my prior skills and experience, establishing that the interface designs Marcus claimed as company property were extensions of techniques I had developed before joining Nexus. She introduced testimonials from industry experts, confirming the innovative nature of my work and its origins in my previous projects. "Most importantly, Your Honor," Grace continued, "we ask the court to consider Statute Section 48.112, which specifically limits the enforceability of non-compete agreements when they are used primarily as retention tools rather than to protect legitimate trade secret." Judge Montgomery looked up with interest. "Counsel, I'm not familiar with this statute. Could you elaborate on its relevance to this case?" Grace smiled slightly. This was precisely the opening we had hoped for. "Your Honor, Statute Section 48.112 was enacted specifically to prevent the misuse of non-compete agreements in the technology sector. While it has been overshadowed by newer legislation, it remains valid law and directly addresses situations like Miss Walsh's." She proceeded to outline the TechVantage case precedent, drawing clear parallels to my situation. As she spoke, I noticed Marcus leaning forward to whisper urgently to his attorneys, who began frantically flipping through their materials, clearly unprepared for this line of argument. Furthermore, Grace continued, "We have evidence that Mr. Wilson has engaged in a pattern of such behavior." She introduced the sworn statements from Alan and David, detailing their similar experiences with Marcus, appropriating their work, and then using non-compete agreements to prevent them from advancing elsewhere. The most damning evidence came last emails from Marcus's own account, provided by Stephanie, explicitly discussing how to use non-compete agreements to keep talent in check and prevent employees from building personal brands that might overshadow the company. Judge Montgomery reviewed the emails carefully, her expression growing increasingly serious. "Mr. Preston, were you aware of these communications?" she asked Marcus's attorney. Preston appeared flustered. "Your Honor, we haven't had the opportunity to verify the authenticity of these alleged emails. They were provided during discovery, with full headers and metadata," Grace countered. "Their authenticity can be easily verified by examining Mr. Wilson's company email account." The judge nodded and made several notes before looking directly at Marcus. "Mr. Wilson, these emails, if authentic, suggest that your primary motivation in enforcing non-compete agreements was to suppress employee advancement rather than protect legitimate business interests. Would you care to address this?" Marcus shifted uncomfortably. "Your Honor, those messages are being taken out of context. As CEO, I have a responsibility to protect our company's intellectual property and competitive position." "By claiming credit for innovations you didn't create?" the judge asked pointedly. Before Marcus could respond, Judge Montgomery turned her attention back to the legal arguments. "I find statute section 48.112 potentially applicable to this case. The statute clearly states that non-compete agreements cannot be enforced when they unreasonably restrict an employee's ability to practice their established profession, or when they are applied in bad faith to suppress professional advancement." She looked directly at Preston. "Counsel, given this statute and the evidence presented, I'm inclined to rule that your client's non-compete agreement is unenforceable in this instance." The atmosphere in the courtroom shifted dramatically. Marcus's confident demeanor crumbled as he whispered frantically to Preston. The other attorneys at their table began passing notes and typing rapidly on their laptops. Judge Montgomery continued, "Furthermore, I find merit in Miss Walsh's counterclaim that Nexus Technologies interfered with her professional opportunities through the bad faith application of an overly restrictive agreement." At this point, the judge cited statute section 48.112 and smiled at Preston. I watched as the lawyer's face froze in recognition of their collapsing case. He frantically scribbled something on his notepad and shoved it in front of Marcus. From my angle, I could clearly see two words circled multiple times. "Settle, now." Marcus's face reddened as he read the note. After a tense whispered conversation, Preston stood. "Your Honor, in light of the court's preliminary assessment, we would like to request a brief recess to confer with our client." Judge Montgomery nodded. "The court will recess for 30 minutes. As Marcus and his legal team hurried out, Grace turned to me with a small smile. "They're scrambling. They know they've lost on the legal merits, and now they're worried about the potential damages and negative publicity if the case proceeds." "What happens now?" I asked, still processing the dramatic turn of events. "They'll offer to settle," Grace replied. "And given the judge's clear indication of how she views their case, we're in a very strong negotiating position." When court resumed 30 minutes later, Preston approached our table, rather than returning to his own. "Miss Thompson, Miss Walsh, my client, would like to discuss a potential resolution to this matter. Would you be amenable to a settlement conference?" And just like that, the power dynamic had completely reversed. Marcus Wilson, who had threatened and bullied me for months, was now the one facing potential financial and reputational damage. As we followed Preston to a private conference room, I caught a glimpse of Alan and David in the gallery, both giving me subtle thumbs-up gestures. The forgotten statute had done what months of struggle couldn't accomplish, forced Marcus to face the consequences of his actions, and opened the door to justice not just for me, but potentially for everyone who had suffered under his predatory business practices. The settlement negotiations lasted for 3 hours in a small conference room down the hall from the courtroom. Marcus sat stiffly across the table, avoiding eye contact as our attorneys hammered out the details. His previously commanding presence had diminished considerably, and he spoke only when directly addressed by his legal team. By late afternoon, we had reached an agreement that exceeded my most optimistic expectations. Nexus Technologies would 1. Immediately retract the lawsuit and void my non-compete agreement in its entirety. 2. Pay substantial financial compensation for lost wages and damage to my professional reputation. 3. Provide a neutral reference for future employment inquiries. 4. Acknowledge my contributions to the innovations I had developed while at the company. 5. Review and revise all employee non-compete agreements to comply with state law. Most importantly, the settlement included no confidentiality clause, meaning I was free to discuss the case and its resolution publicly. This was a point Grace had insisted upon, knowing that transparency would help protect other employees from similar treatment. Mr. Wilson was very resistant to excluding a confidentiality provision, Grace explained as we left the courthouse. But once the judge made it clear she found merit in our counterclaim under statute section 48.112, his attorneys recognized they had little leverage. The potential precedent this case could set was too dangerous for them to risk a public trial. The financial settlement provided immediate relief from the mounting debt I had accumulated during my unemployment. I could pay my mortgage, restore my retirement savings, and even afford to take some time to carefully consider my next career move, rather than accepting the first available position. Within days of the settlement, word spread throughout the tech community. Alan reached out to congratulate me and share that he had secured a new position at a progressive tech firm that specifically prohibited the type of restrictive agreements Nexus had enforced. David invited me to speak to his team about professional rights in the technology sector. Most surprisingly, I received a text message from Stephanie Marcus, resigned this morning. Board meeting called immediately after. Rumor is they're completely restructuring the company and leadership. Thank you for standing up when no one else would. Marcus's resignation marked the beginning of significant changes at Nexus. Patricia from legal was also asked to leave, and the board appointed an interim CEO who immediately announced a company-wide review of intellectual property attribution and employment practices. Several former employees were contacted about proper credit for their innovations. 2 weeks after the settlement, I received a job offer from Horizont Solutions, a respected company known for its ethical treatment of employees and collaborative approach to innovation. The offer letter specifically mentioned that they had been impressed by my stand against abusive business practices, seeing it as evidence of integrity they valued in their team members. My first day at Horizont felt like stepping into an alternate reality of what Nexus could have been. My new manager, Jennifer, began our orientation by reviewing the company's innovation attribution policy, which ensured that employees received proper credit for their contributions, while the company maintained necessary commercial rights. We believe that recognizing individual contributions strengthens our company rather than threatens it, she explained. When our team members build their professional reputations, Horizont's reputation grows alongside them. Over the following months, I reconnected with Stephanie and Alan, who had both also found positions at companies with more ethical practices. The three of us, along with David and several other former Nexus employees, formed an informal support network for technology professionals facing similar situations. This network eventually evolved into a more formal organization, Tech Equity Alliance, dedicated to educating employees about their rights and advocating for fair employment practices in the industry. We developed resources explaining complex legal concepts in accessible terms and provided referrals to employment attorneys familiar with the unique challenges of the technology sector. My experience with Statute Section 48.112 became a cornerstone of our educational materials. We discovered that many states had similar forgotten statutes that had been overshadowed by newer legislation but remained valid and potentially powerful tools for employees facing unfair restrictions. The ripple effects of my case extended beyond individual employees. Several technology companies in the region reviewed and revised their non-compete policies, recognizing that the legal landscape was shifting against overly restrictive agreements. Industry publications began examining the ethics of intellectual property attribution and employee mobility more critically. 1 year after the settlement, I was invited to speak at Tech Forward again, this time about the intersection of innovation, attribution, and employee rights. As I looked out at the audience of developers, engineers, and company leaders, I shared the lessons my journey had taught me. Knowledge is your most powerful protection. Understanding your rights, documenting your contributions, and being willing to stand up for yourself can make all the difference. But equally important is building community. None of us can challenge these systems alone. It takes collective action and mutual support to create lasting change in our industry. The talk received a standing ovation, and afterward numerous attendees approached me with their own stories of facing similar challenges. Each conversation reinforced what I had come to believe, that my difficult experience had served a greater purpose by helping others navigate their own professional challenges. Today, 3 years after my confrontation with Marcus, I lead a team of developers at Horizont, where I'm known for my commitment to mentoring junior team members and ensuring they receive proper credit for their innovations. The software we create together is more creative and impactful than anything I developed under the oppressive environment at Nexus. The forgotten statute that saved my career has now become widely known in the technology sector, cited in numerous cases challenging abusive non-compete practices. Legal experts have dubbed it the Carmel Clause, in reference to how my case brought it back into prominence. Sometimes I reflect on that moment in the courtroom when the judge cited Statute Section 48.112 and the look of panic on Marcus's face as he realized his control was slipping away. That single moment of accountability required months of struggle, research, and courage to create. The most valuable lesson I learned wasn't about legal statutes or employment contracts. It was about the power of persistence and the importance of fighting not just for yourself, but for all those who might face similar injustice. By standing up to one person's abuse of power, we created a ripple effect that continues to protect others. Have you ever faced an unfair situation at work that seemed impossible to overcome? What resources or support helped you through it? I believe sharing these stories helps all of us become more informed and empowered in our professional lives. Please like this video if you found my story valuable, subscribe for more real-life experiences, and comment below with your own workplace justice story. Together we can create workplaces where talent is recognized, innovation is rewarded, and everyone has the opportunity to thrive. Thank you for listening to my journey.